When you get on the first piece, there we go. And no longer. I'm sorry, I'm in the back. You feel right. Brian, you can hear me. You can hear me, Brian. Right, that's right. I'll see. Right. All right. Court of Appeal in for the 6th District of the State of Florida is now in session. The Honorable Jeremy Smith, Judge presiding. All persons having business before the court shall near give attention and you will be heard. God save the United States of America, the state of Florida, and then the Honorable Court. Please remain standing to the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
You may be seated. Good morning, everyone. Welcome. Introductions, we'll start with that. Judge Jared Smith, I'll be presiding today, and then we have to my right, Judge Keith White, and to my left, Judge Josh Mize. We are going to switch up our cases just a little bit. We'll call 23-1401 first, Lisa Hines versus Westgate Resorts, Inc. et al. And counsel, if you could state your appearance for the record.
Jeffrey Marks on behalf of the appellant Lisa Hines.
Okay. And counsel, how much time would you like to reserve for rebuttal?
5 minutes, please.
Okay. Okay, you may begin.
May it please the court, Jeffrey Marks on behalf of the appellant Lisa Hines. This is an appeal of an order dismissing a second amended complaint with prejudice and denying substitution of parties. The issues before the court are fairly simple and straightforward in terms of the matters that we raise in our brief. They are independent, but they are intertwined. The reason why I say that is because one is a discovery issue, denial of discovery, and the other is related to the relation back issue.
Counsel, if I could stop you there for a moment. With respect to the discovery issue, how is it that we have jurisdiction over that issue?
I think it's part of the dismissal order as being part of the, we have jurisdiction over the denial of discovery as a previous non-final order that is subsumed within the final order of dismissal.
But the dismissal was against Westgate Vacation Villas LLC, correct?
The dismissal was against Westgate. Let me apologize in advance if I mess up the Westgates. It's not done on purpose. And in fact, as I get into my argument, I'll show why it's easy to do that. The dismissal, I believe, was against Westgate Resorts with prejudice, Your Honor. I believe the denial of the substitution of parties, and then ultimately the dismissal of the pending complaint, second amendment complaint, was against Vacation Villas.
Right. The order on appeal is the order granting defendant Westgate Vacation Villas motion to dismiss and denying plaintiff's motion for leave to substitute Westgate Vacation Villas.
Correct.
Okay. So the appellant there is what I'll call villas.
Okay.
The discovery orders, based on my review of the record, are with respect to resorts.
Right.
There is no final order as to resorts. And so how would we have jurisdiction?
I believe the order is a dismissal with prejudice of the claim against resorts. And if the discovery order,
I don't see that.
okay.
Well, let me ask you this. If there is not a dismissal of resorts, would you agree we don't have jurisdiction to review any prior order denying discovery sought against resorts?
Yes. Yeah,
Okay.
I would. But I think the answer is yes, I agree. I agree with that statement. I think what happens here, Your Honor, is the core issue is relation back and substitution of parties. And then, as I said, the tangential issue is the issue of discovery and the denial, the prevention of the plaintiff from getting discovery to go to that issue. As I said, it's our secondary issue, it's not our primary issue, but going right to.
So I have a question about that, counsel. So we're dealing with an exception here, right? Generally, relation back doesn't apply to new parties.
That's
so
correct.
what we're dealing with is the scope of this exception.
Correct.
And the way I read the case law is that the exception applies when the new defendant, right, the party you're trying to substitute in, knew or should have known that they were actually the intended defendant.
That's correct.
Right. So you have sufficient overlap between the two entities that the new entity, they knew it was supposed to be them. They knew it was a mistake. And my question about that is when they had to know. And you seem to answer that in your brief. And it says, I'm reading from page 21. Furthermore, for the relation back doctrine to apply when adding a new party, the newly added party must have had knowledge of the litigation prior to the running of the statute of limitations and knew or should have known that the plaintiff had made a mistake or was guilty of misnomer. That makes sense, because that's what, things like Rayner, Schwartz, Kozich all have that same standard. But then you say in your brief, well, look, we filed it before the statute of limitations, and they have identity of interest, they're overlapping entities. But even if you assume they were completely overlapping, right? Assume that these were one and the same, complete identity of interest. And so you assume that Westgate Resorts told Westgate Villas about it, or they knew the second the lawsuit was served. Isn't the earliest we can assume that Villas had knowledge of the lawsuit the date when Resorts was actually served?
Yes,
Filing a lawsuit doesn't get you knowledge, service does, right?
that's correct.
Okay, so the incident here occurred on September 4th, 2015. And I can see that the complaint was filed in August of 19. What date was service of process made?
I'll have to go back and look at the actual record to see when the return of service was filed, Your Honor.
So I guess what I'm saying is, on this record, if the earliest you can assume the knowledge, because you're asking, it's your burden, right? And you're asking us to impose an, arguing that you satisfy an exception. The earliest date that the newly added party can be charged with knowledge is service. But as far as I can tell, we don't have the service date in the record.
No, Your Honor, I don't believe, I don't know if this return of service was filed or not. Improper for me to tell you that it was or wasn't. I can certainly look at the record. It seems like Your Honor has looked at the record, but I don't think that that's the way the identity of interest.
No, I'm saying assume you have identity of interest.
Right.
I'm saying assume these are just complete overlapping of these entities. They're essentially one and the same, that they're just a ruse and they're the same. Still, if you assume that Villas had all the knowledge Resorts have the very second they had it, you still can't assume knowledge before Resorts was served, right?
I don't know if I would necessarily agree with that because of the preceding events as it relates to the interaction of the parties. I mean, it's a knew or should have known standard, okay? And knew or should have known encompasses the exchange between the parties prior to the lawsuit.
So there's a bunch of cases that says that's wrong, like what you just said. So we got Rayner, right? That's the 5th DCA case, which I guess was binding at the time, not anymore. It says a claim is not necessarily a lawsuit, and it does not follow that a lawsuit will always be filed following the notice of the claim. Rayner held that it's actual knowledge of the lawsuit, not the claim. Kozich said that. Schwartz said that. Patel said that. HSBC said that. And then Michelin Tire didn't say it completely, but they, one of the bases for the dismissal was that the German company was not informed of the lawsuit until after the statute was run. So if we were to find that it was not the knowledge of litigation that mattered, we'd be going against 1, 2, 3 other DCAs, wouldn't we?
If that's what those cases say and that's what they hold, and I'm not arguing with Your Honor that that's what they hold, but the fact that also the court has to remember that when a complaint is filed, the statute of limitations is told at that time. So
yes, but we're not talking about the tolling of the statute of limitations as to the original party. It's not told, it's satisfied, right? Because you have to file. Tolling extended. It's not extended. You've satisfied it, right? You filed it before the statute of limitations. But the exception for a different party against whom the new lawsuit was filed is different. And you've given us a standard that this is in your brief. So I'm entitled to hold you to it. You don't get to run away from it now. You say in your brief that the newly added party must have had knowledge of the litigation prior to the statute, prior to the running of the statute of limitations. That's the standard you have asked us to apply. And so what I'm saying is, point me to anything in the record that shows they had knowledge of the litigation. That's the word, that's what you said, prior to September 4th, 2019, which was the running of the statute.
It's not a new standard, it's a new or should have known standard. As interpretation of the identity interest. I don't believe that this is an argument that's been advanced by the other side for the basis for denial.
So hold on. The new or should have known is for the fact that it was a mistake, the fact that the entity was wrong.
An identity of interest.
Yeah, correct.
That's the
correct.
Right.
For knowledge of the litigation, it is not new or should have known. This is your brief, counsel. I'm entitled to hold you to it.
I got it. I got the point.
Okay. So don't run away from the question then.
Okay.
You say knowledge of the litigation prior to the running of the statute of limitations. That is what you have asked us to apply as the standard. Give me something in the record that you have presented to us as the party seeking to overturn the trial court that the new party had knowledge of the litigation prior to September 4th, 2019?
Standing here now, I cannot give you something to contradict or modify or assuage what I stated in the brief. As I said, the record, I don't know about the service date of the complaint and when it was done. I don't know one way or the other if the record is in. I think if it were, you would tell me that it was in there. But I'm not going to run away from the statement I made in my brief. But I also.
So would you see then that to win, because you're held to your brief, you can't change it now. To win, you would need us to show us service before September 4th, 2019, or on or before?
If in fact that's what the case law holds, and I don't have the cases sitting in front of me, so I can't,
Well, hold on. We're a different DCA, so we can disagree with the other DCAs, right? So, but I'm entitled to hold you to your brief, right? So your chance to ask us to disagree has gone because you filed your brief and you didn't ask us to disagree, did you?
Well, if there's, I made the statements I made in my brief, and I'm gonna stand by them. I'm not gonna run from them. Okay. And your question is, point in the record where there is any evidence to demonstrate that the added defendant knew of the complaint. And the answer is I can't stand here, okay, without looking at the record, which I'll do during the.
Yeah, and we can ask you to supplement the record. I guess what I'm saying is, based on the standard you've asked us to apply, in order to win, do you have to show us a service date prior, on or before September 4th, 2019? And if not, why not?
Well, I'll be forthright. I wasn't prepared to answer this question because it's not an issue that was briefed.
It wasn't briefed. You put it in there.
I understand that. I got that. What I'm talking about is that it's not an argument that was addressed in the answer brief, and I don't believe you responded to it in your reply brief because it wasn't pointed out. So you've got me at a disadvantage, which is you're asking me a question that I actually hadn't thought of. Okay. And so the answer is I stand by my brief. Obviously, if there's supplemental authority, we're going to do that. But I do think that if I can move away from that, okay, and discuss how.
Counsel, I need to know whether I need your record supplemented. You can't move away from it. I need you to answer the question.
Well, counsel, I'll jump in too. I mean, on page 12 of the answer brief, they state Hines has not demonstrated that the relation back doctrine should apply because Hines has not been established that Vacation Villas was aware of the lawsuit prior to running the statute of limitations. I mean, isn't that exactly what you were? Isn't that what you're saying on page 21 that you would have to show that they had knowledge of the litigation, and then they're arguing you didn't show that they had knowledge of the litigation? How are you saying that wasn't raised in the brief? So I'm not quite sure how you're saying you weren't prepared to argue that today.
I'm talking about the fine point of the specifics of the question that's being asked. I can't do anything more other than tell you I don't have an answer for the board. I can't point to anything in the record. If the true identity of interest test is dependent upon actual service of the complaint, then that's what the case law holds. Then and
counsel, so you're missing the idea of presentment, right? So if you want us to disagree with other DCAs or hold something, you have to ask. We can't take it out of thin air. And so it's not the issue of what the case law holds, because we don't have any case law on this issue, right? Like we're bound by the Florida Supreme Court. We're not bound by another DCA. So, but we are bound by what the parties ask us to do. We can't inject issues.
I understand.
And so it's not what the case law holds. You put that in there. You're bound by it now.
Okay. Well, if I've misstated the case law, then that's on me. Okay. But I don't think I've misstated the case.
I'm not saying you misstated it. I'm saying that you gave up your opportunity to ask us to disagree with the other DCAs. I'm not saying you misstated the DCAs. I think you accurately stated them.
Right.
But you've, in terms of asking us to change the standard or to disagree with the other DCAs, that time has passed. And so we're under a certain standard. And so I'm just asking you how you meet it. Like, how do you meet the standard? What piece of evidence can you show me, right? Because you admit it's your burden on appeal, right?
I understand.
What is the piece of evidence that would show me that you meet the standard that you've asked us to apply?
The only thing that I can point to is the pre-suit demand letter, which is in the record, and the communications between the plaintiff's counsel, trial counsel, and Westgate Vacation Villas Resorts, because that's how they refer to themselves, as an intent for litigation. Now, intent doesn't get me to where I overcome actual knowledge, then I have a problem. But I think that the record demonstrates an intent on the part of the plaintiff to commence litigation.
So counsel, if I'm understanding what you're saying is that you believe that your knowledge of a pre-suit litigation letter would be knowledge of litigation? Would that be your position?
Potential for litigation, yes.
Okay.
I think, and I think if you take that and add it on to the liberal policy behind relation back, which the Florida Supreme Court has addressed in the Coppell case, I'm sorry, where it talks about the three factors in applying 1.190 as being interpretation being consistent with the judicial policy of freely permitting amendments. Relation back is consistent with rule 1.190 and also tends to the issue of statute of limitations and stale claims.
That case didn't involve the exception for new parties, did it?
No, but it's a policy statement. I think that applies across the board to the relation back and analysis and the exception, and the exception has been applied and it's been stated as though there's a file in our supplemental authority.
Counsel, you're under your rebuttal, just so you know.
So the best I can answer your question is that if the record shows that there's pre-suit litigation commencement or discussions between the plaintiff's counsel and the defendant who used several different versions of its name and not so I think that meets the new or should have known standard. And I think that the court erred in dismissing this case on the issue of relation back as violation of the policy, and I'll be waiting my time for the rebuttal.
Okay. Thank you.
Good morning. May it please the court. Teresa Bone on behalf of the appellees. I'd like to start jumping into the questions that have been asked of my colleague. Judge White, to your point related to the issue 2 of the financial discovery, you are correct to state that the production requests were to Westgate Resorts Incorporated. That's located on the record at 287. And the order, therefore, as it relates to Westgate Resorts Incorporated for the discovery would not be subsumed in an order dismissing Vacation Villas LLC. Judge Mize, I'd like to turn to the questions that you asked my colleague.
I'd like to give you one extra fact as you address those. So the flaw in the argument I was referencing is that, most of those cases dealing with knowledge of the litigation were resolved to summary judgment.
Sure.
All right. So I used to represent corporate clients. They monitor litigation, right? And law firms monitor litigation of all their clients, so they can send them and say, hey, hire me, right? I'll bet, you or other firms, you probably have all your clients on a litigation alert, right? And the second that litigation is filed, you find out about it and you email your client before anybody else and say, hey, this lawsuit was filed against you. I'd love to help you with it. So, lawsuit was filed in August of 2019. Statute ran September 4th, 2019. Regardless of when service happened, isn't knowledge of the lawsuit an issue of fact? So if they were to depose Westgate Villas and ask the corporate rep, do you have litigation alerts through Lexus or Westlaw or whoever that tells you the second you're sued? Yes, and they're saying, did you get knowledge of this lawsuit? And it's not coming from an attorney, right? If it's coming from Lexus, that wouldn't be privileged. Did you get knowledge of this lawsuit within 24 hours of it being served, actual knowledge? And they, assuming that, I don't know what would happen. I don't know, but potentially it's an issue of fact. Did you get knowledge of this lawsuit the second it was served? Yes. Wouldn't that then meet the knowledge standard?
I don't believe so. And I don't think it is a question of fact that's proper on summary judgment. And the summary judgment, as we all know, this is not an order on a summary judgment. The knowledge factor is based on service, as you had indicated.
Why?
The service, because that's knowledge of when the litigation is. And if I could go back.
No, but also going to the courthouse and getting a cop. No, the cases don't say service, they say knowledge. Now, obviously, service, you get to assume knowledge. Service, as soon as service happens, there's knowledge, right? So that's the earliest you can definitely assume it. But you can certainly get knowledge earlier, right? I had clients, I emailed them the second they got sued. They did not have to wait for service. The second my clients got sued, I emailed it to them and said, hey, you've been sued. You want to hire me? So none of the cases say service, they say knowledge, don't they?
That's correct. And knowledge of litigation is not the same as a claim letter. A claim letter is not knowledge.
Counsel, don't change the question. I'm not talking about a claim letter. I'm talking about the lawsuit is filed and they get a copy, right? Lexus emails them and says, you've been sued. Here's your litigation alert that you pay us a monthly fee for. You've been sued. So August, whatever it was filed, August something before September 4th, they get the actual lawsuit. Is that not knowledge of a lawsuit?
If that actually happened, that is not in the record.
But
We do
that's
not-
my point. It was a motion to dismiss. What that's the knowledge, the date they were served or how they found in the lawsuit, that wasn't in the four corners of the complaint, was it?
The date of the lawsuit was that in the forecourt.
The date they were served. Like this is the motion to dismiss, right? There wouldn't have been any issues of fact. And that's my point.
But-
If the issue is knowledge, how can that be resolved on a motion to dismiss?
Because this is also a motion for substitution. There are two motions that were at play here. It wasn't just a motion to dismiss, and I agree, a motion to dismiss is the four corners of the complaint. You can't go outside of it like you can in a summary judgment. But here, there's also a motion for substitution. And when looking at the transcript from the trial court's hearing on this, the trial court ruled on the motion for substitution first. So the substitution, I think, is also paramount, and that can go outside of the four corners. In terms of looking at when it was served and whether they received notice of it as soon as it was, as soon as the complaint was filed on August 28th, 2019, there is nothing in the record to show, as you indicated, that there may have been some type of notification, whether that's internal Lexus, third party. What we do have on the record, however, is a statement in Westgate Resorts motion to dismiss that it was served with original process on October 1st of 2019. That's at 357 of the record. That was further confirmed by Hines in the trial courts.
Record, counsel, if I may, I don't dispute that the data service was after the statute of limitations. So moving on from that point, let's go to the kind of the heart of the argument, which I think is what I see as the dividing point between your position and your opponent. Is the concept of, do you have to actually know that a lawsuit has been filed? So if we follow your position, we would create a state of the law that would effectively make it impossible in a situation where someone has sued the wrong corporation. You know, if they sue ABC Inc., but it should have been ABC LLC, all the same assets, all the same membership and all that, just wrong corporation. There were two different companies and they sued the wrong one. I'm not talking about the Cabot versus Clearwater Construction, which is a misnomer. I'm talking about a mistake and two actual existing entities. If we follow your position, if anyone were to ever sue on the date the statute ran, which happens often, a lot of times that occurs, it would essentially be pretty much a given that if the real corporation in interest wasn't properly sued, there's no way they're going to find out about that before the statute of limitations run, not the actual lawsuit. Very rare that you have attorneys like Judge Mize apparently is watching all the feeds out there. And but for most cases, that would be the end of the story. If we follow your opponent's position, there's another line that kind of opens up to where we look more toward did they know that there was a claim out there somewhere? My hang up that I will be frank with you on is the Schwartz case, the Schwartz versus Will Chamberlain. So in that case, the statute of limitations, the suit was filed against the wrong corporation 3 or 4 days before the statute of limitations ran. It was September 30th versus August 3rd. And the court says nothing about, oh, this was a miracle service. They walked it into the courthouse, and unlike any other case, they had this thing, they found Wilt Chamberlain LLC. Guess he was tall enough. No, just kidding. No, they find Wilt Chamberlain LLC and they serve them literally the same day they walk through the courthouse doors, which is rare. I mean, generally you're hiring process servers. They've got backups of, 30, 45 days, and that's normal. So often we see extensions being asked for on the 120-day service time as trial judges, which we all were. So there's, in my honest reading of Schwartz, I cannot read into that that the wrong entity was given actual knowledge, even the right entity had actual knowledge of the paper lawsuit being walked through the front doors of the courthouse. Do you read Schwartz any different than I'm reading Schwartz?
I think I agree with you, Judge Smith, in the sense that Schwartz is silent as to when that service occurred. It's just not on the face.
Sort of. Because they actually say in the Schwartz opinion, they say that the opposing party, the wrong corporation, if you will, the right one that wasn't sued properly, had early knowledge of the litigation.
Correct.
In your experience, would you consider 4 days ahead of time early knowledge of the litigation? Would you be telling your clients, we really knew about this early, we found out about it 4 days ago? Could you reconcile that with the position that it would, that they knew about it more than 4 days before it was filed?
I think what the case law demonstrates, and whether it's the Schwartz versus the Wilt Chamberlain, or the Rayner case, or the Kozik case, that it discusses early knowledge of litigation. And what that means is prior to the running of the statute of limitations. And that's what's indicated in the Michelin case, which.
But how could they have how in the Schwartz case? Really, my problem is with the Schwartz case. How in the Schwartz case could you honestly say that the Schwartz panel of judges is not misleading the state of Florida by using a word like early knowledge of litigation when it was only 3 days ahead of time that they knew about it? How could they really be saying early knowledge of
I think it's
litigation?
prior, I apologize to.
Yeah, no, go ahead.
I think the concept is that it has to be prior to the running of the statute of limitations.
But would you call that early? Wouldn't that be deceptive to use a phrase like early knowledge of litigation? Shouldn't they have said, we threaded a needle here. They got, I mean, that would be, don't you think that would be an important fact for that court to have put in their opinion? Hey, just to make sure everybody understands, when we use the word early, we mean they threaded the needle within 72 hours of the time that they walked this in the courthouse. They had it served on the other side. And thus, what we mean by early means 72 hours.
I think that is a difficult thing to reconcile, especially when you have a plaintiff who waits to the end of the expiration, or excuse me, to the end of the statute of limitations.
I appreciate your honesty. It's difficult to reconcile because that's what Schwartz is honestly is my most difficult case to wrestle with your side of this. And my problem with that is that Schwartz, the last big speak on this that I can find from the Florida Supreme Court is the Caduceus case. And in Caduceus, they cite Schwartz. They call out the Schwartz case as well as the Kozik case. But when they called out the Schwartz case, how are they not endorsing the fact that early knowledge of litigation does not mean that they knew about the lawsuit itself, but they knew about, as your opponent's saying, pre-suit knowledge of it. And the reason why I say that, and this is, I guess, would be kind of my follow-up, in the Caduceus case, that is an adding of a third-party defendant
Correct.
as a defendant
Correct.
by the plaintiff. Now, if we went with your standard, which is that they'd have to know about the lawsuit itself, Caduceus would no longer be good law. Because under Caduceus, and you tell me that I'm wrong on this, okay? Tell me that I'm seeing this in the wrong way. Caduceus couldn't be good law if I follow your position, because in Caduceus, if a defendant waited until the running of the statute of limitations to file a lawsuit, and then took the typical 120 days to complete service on a third-party defendant, that third-party defendant did not know about the third-party complaint or the litigation until 120 days after the running of the statute of limitations. How does that not totally violate everything that would be your position in this case is the winning argument?
I don't think it violates Caduceus because as you pointed out, that was a third party defendant. So that was someone who's already in the lawsuit. And I think.
Well, sort of. I mean, they don't even know about it. So here's this plaintiff out there that has never filed a lawsuit against this third party defendant. The defendant files a lawsuit against the third party defendant. The plaintiff, no. They've never asserted, probably not even written a pre-suit demand letter to this third party defendant. And 120 days after the statute of limitations runs, they're talking to their insurance company. They're saying everything's hunky dory. We're not going to, this plaintiff can't sue us if the statute of limitations is run. 120 days later, they get a piece of paper that says you're now a third party defendant. And then 2 or 3 years later after that, they find out, oh, now the plaintiff can sue me. Whoa. I didn't find out about this until after the statute of limitations. I didn't find out about this lawsuit at all until after the statute of limitations ran. How do I reconcile that with what would be your position here today?
Sure. I think Caduceus it's factually distinct. You have a third party defendant, and that is exactly what Caduceus and the Florida Supreme Court discussed, was that it's changing the alignment of the parties, that someone who is now a third party defendant is now brought up into an actually party defendant. I think the other thing that is important that the Florida Supreme Court pointed out in its discussion as to a third party defendant is it also discussed about the purpose of statute of limitations, that it's supposed to protect the defendant from the unusual long delays in filing of lawsuits, prevent prejudice to defendants from unexpected enforcement of stale claims, prevent surprises through revival of claims allowed to slumber until evidence has been lost, memories have been faded, and witnesses have disappeared. Now, I also believe there's another Schwartz case that has been cited, the Schwartz versus Metro Limo case, I believe.
Well, let me, before you get on to that.
Sure.
So when I look at the actual reasoning on the Supreme Court's decision in Caduceus, this is what I see. They say that the key inquiry is whether the third party complaint put the third party defendant on notice of the transaction, occurrence, or conduct from which the plaintiff's claim arose. Isn't the key inquiry notice? So if somebody knew about the facts, the transaction, the conduct, if your client was on notice, shouldn't that be satisfaction of what seems to be the reasoning behind the Caduceus decision?
No, because there was no notice in this case. And to build on Caduceus is a case law from Patel, where it says that a notice of claim is not sufficient for purposes of litigation. So a notice of claim, and that is something that my colleague pointed out, and I will admit there were two notice responses by Westgate Resorts, not Westgate Resorts Inc., not Westgate Resorts Vacation Villas LLC, just Westgate Resorts. There were two claim letters, one I believe in 2018 and one I believe in 2019. But under Patel, and I believe even under Rayner, a notice of claim is not purpose for putting someone on knowledge of litigation, and that makes sense. Litigation hasn't ensued.
Well, I think if we follow Rayner, if you get us to follow Rayner, I think you win. I think you win under Rayner.
I agree.
My problem is that Rayner's 2010 and Caduceus is 2014. That's my challenge. Rayner was cited by the lower court in Caduceus that got quashed, overturned by the Supreme Court. The first DCA relied upon Rayner, and then that reasoning was, I think, effectively overturned by Caduceus. Instead of citing to Rayner in Caduceus, the Florida Supreme Court cited to the Schwartz case, which I unfortunately, I can't be being intellectually honest in my read of it. I cannot read Schwartz to stand for the proposition that this this third party, this defendant that hadn't been named in the lawsuit actually knew about the lawsuit itself, somehow found out about it 4 days after, and the court never even mentioned that as a relevant fact.
Counsel, since Schwartz didn't address this issue explicitly, could that inconsistency be explained that just no lawyer raised it?
Potentially. I mean, I think we get into hypothetical and speculative theories as to why something is or is not on the face of an opinion. What I do know is that what Rayner says, what Michelin says, what Kozik says, and that's that the relation back doctrine does not apply when a new party had knowledge of the lawsuit, when it did not have knowledge of the lawsuit prior to the expiration of the statute of limitation. The case law is clear that notice of claim, a response to notice.
Counsel, I would say this, in federal court, why would we not just adopt the federal standard, which adds an extra 120 days onto it? And they say, well, you filed it within, and everybody knows that after a lawsuit gets filed, there's 120 days you have to serve a party. Why shouldn't we look at it like your opponent says, which is, well, once that lawsuit's filed, there's a tolling period that goes into place. So technically we comply with all of these cases. You still have knowledge within the statute of limitations by adding the service time.
Well, that wouldn't be the state of the law at the time that this was occurring. And
but did anybody talk about the service time? I mean, did Rayner talk about potentially adding the 120 days? Did Kozik talk about adding? So how could we be violating something that the courts have never said isn't potentially a viable way of looking at it?
Admittedly, I don't know if the cases went into the detailed discussion of the service time. What I do know what these cases talk about is the relation back doctrine cannot be applied when you have a new defendant that's trying to be sued after the expiration of the statute of limitations, and where you have a defendant who has lulled a plaintiff into the incorrect belief that they were the right individual to sue.
Didn't you lull them into the belief that you were the right entity to sue? I mean, you corresponded with them and said, this is our Westgate Villas in your letter. I mean, if any reasonable person, wouldn't they've looked at that to say, okay, Westgate Resorts, they're calling it, they're corresponding, they're making offers back and forth, and they're calling it our Westgate Villas. How have you not lulled them? I don't know that the lulling argument necessarily goes in your favor, frankly. And I don't know that we're really lullers up here. We're really more focused on what probably the bigger picture is, and that is whether we go with the knowledge of the litigation versus knowledge of the claim itself versus specifically knowledge of the lawsuit. But I would like to. I don't know of any of these cases. I've looked through the Florida cases. The problem is none of them come close to the service date like what we have here. And
I agree.
that's the challenge is, should we, since this is a case of first impression, I guess, so to speak, should we go ahead and add, accept your opponent's argument and say, well, let's look at it like the statute of limitations is told, like it would be with any lawsuit. So now we've told it, we've got 120 days. You did find out within 120 days. You just told us it was October 1st. So that was well within 120 days, the date it was filed and the date the statute ran. Why shouldn't we go with that argument?
Because I think, and I know you relied and we discussed caduceus, but I don't think caduceus is factually similar for purposes of this, and caduceus does not overrule Rayner. The Florida Supreme Court could have overruled the cases, and it did not. Rayner is still good law. Patel is still good law, and I recognize and understand that this court has the exciting opportunity to write cases.
But what I'm saying is, in Rayner, they never talked about potentially adding a few. They never talked about the possibility of a tolling for a period of service, did they?
Not that I'm aware of, Your Honor,
Yeah.
but I don't believe that the tolling has really been addressed and discussed. I mean, these issues,
Is there a federal rule that provides for that, counsel?
off the top of my head, I don't know.
Okay.
I have to be very candid.
Florida doesn't have any rule that provides for that, though, right?
Not that I'm aware of either. And if there is, it definitely has not. I've not seen that briefed or addressed in this case. I know I'm running out of my time. Really briefly, if I could conclude, this court should affirm the trial court's orders since Westgate Vacation Villas LLC was not served until after the expiration of the statute of limitations, and the amended complaint did not relate back to the originally filed complaint. And for the reasons discussed today and those not answered, we would ask this court to affirm.
Okay.
Thank you.
Thank you, Your Honor. Thank you. All right, Councilman, proceed.
Thank you. I'd like to address a couple of things. So often I get to say that sometimes the court makes a better argument than I did. But I think that the questionings in the appellee's argument are in line with the policy behind relation back. I mean, the policy behind relation back, liberal policy of amendment, is to make sure that the plaintiff has got the right party if there's a sufficient identity of interest. And we all know what the test is for sufficiency of identity of interest. And while we haven't really discussed that here, I think that it's well met by the plaintiff here. You've got overlapping corporate officers, same counsel, same address, phone number. We have the pre-suit communications rolling the names really all into one. And you've got the corporate officers of one corporation sponsoring certain certificates as it relates to
Can
transportation.
I ask one more question on that? If we all agree that we think you satisfied the identity of interest, does that moot your discovery issue?
Well, I
But
think
we just think you went on that, like you didn't need more information. We just agree with you.
if
That moots all the discovery.
yes, Your Honor, of course, if the court reverses and says that
Well, I didn't say we reverse. I said we agree with you on identity of interest, right? Because we could still disagree on the knowledge portion.
that.
But I'm saying that the
See, I'm gonna
discovery,
go for the whole thing.
Yeah,
I get it.
the discovery is specific to the identity of interest issues, right? If we think you won that anyways, we don't need the discovery, right?
Yes and no, and I'll tell you why.
Okay.
You raised the issue, Your Honor, about now notice, the court raised the issue about notice being a factual issue. And so to the extent that the plaintiff was not afforded a full opportunity on a summary judgment motion to conduct full discovery on this issue, and the purpose of the discovery is to show the interplay between the two corporations and the issue of knowledge and notice, then the answer is.
Did you serve any discovery on that issue?
Well, we attempted to serve discovery.
Did any of it say, when did you learn of the lawsuit?
I'm Sorry,
Did any of the discovery say, when did you learn of the lawsuit?
I don't believe so, Your Honor.
So you
I
didn't
think
serve any discovery on that issue?
I think that's certainly, the discovery that was served in 2 points, obviously depositions and then later request for production. The court was very restrictive in allowing what we could conduct discovery on the issue.
But did you ask? Did you serve a request?
I
Did you say,
can't-
Judge, I want to do this?
I can't tell you what the specific, if there was a specific request one way or the other. I can tell you that the intent was to conduct discovery on the issue of identity of interest, in which one then shows the issue of knowledge and so but as I said, I think we meet the identity of interest metric, and I think we meet the tests as set forth by the various courts. But the issue is one of notice, and the reason why we have a relation back doctrine is to allow a plaintiff to correct a misnomer or make sure that the right party gets it. And we cite a federal case that talks about, the plaintiff being confused because of the nature of the corporate transactions. Not suggesting that something like that occurred here, but we do have a factual record which shows that a representative of the defendant, a representative loss control manager, was using the terms interchangeably. And so on the issue of notice, okay, this record is silent as to whether or not resorts, I'm sorry,
Did
resorts.
the trial court, at the hearing on the motion to substitute, the trial court take evidence?
No, Your Honor.
Did anybody ask her to take evidence?
I don't believe it was an evidentiary hearing, and I don't believe we asked for it to be an evidentiary hearing.
Did anybody ask? So nobody asked for an evidentiary hearing, and nobody served any discovery on the issue of when they got notice, right?
I can't say, the answer to the first question is, I don't believe it was anybody requesting an evidentiary hearing, is whether or not anybody served discovery on the actual issue of notice. I can't tell you that there was a specific request for reduction that says, on that particular topic, but that's certainly within the penumbra of what could have been discussed in the deposition, the documents, and the trial court said basically no discovery, take one limited depot. So I'm running out of time, but I think that the issue here is, in order to give effect to the relation back doctrine and its policy of liberality application, the court has to reverse and identify that the plaintiff did serve the proper party. And so we've asked that you reverse.
Thank you, counsel. Thank you both. Yeah, the court's going to take a brief recess.
Is it supposed to?
It's just the way it is.
No, it's okay. I just was nervous.
I knew my, I always do my math from the morning time, and it says, okay, it's gonna take 2 hours to get there. So I'm like, I'm gonna only need 3 hours for it. And so I left at like 7, and literally, right off the gate, I wear happens on in Jacksonville on 95, I mean, like 15 minutes. And then one happens later on, and then keep telling that. And another one happens, so it's just, it was just really close. I was in Chicago. Mhm.
Good morning again, everyone. I don't see any new faces. Everybody here when we did our introductions. Okay, so we're here now for Walmart Store East versus Jessica Amador and Lori Gunn, case 23-1335. Counsel, could you please state your appearance for the record?
Yes, Jack Ryder on behalf of Walmart.
And counsel, how much time would you like to reserve for rebuttal?
5 minutes, Your Honor.
Okay, you may proceed.
Thank you. May it please the court. Again, my name is Jack Ryder here on behalf of Walmart. Your Honors, here the court clearly erred by allowing the plaintiff to invade Walmart's work product privilege in the middle of trial and then to reveal that statement to the jury in the middle of the proceedings. Now, I'll start from the premise of the fact that the court below found this statement, this accident statement, to be privileged, and that has not been challenged on appeal. So the questions that have to be evaluated before the trial court, and we believe the court erred in doing so, was one, did the plaintiff satisfy the burden of showing a need for this statement? And number two, an inability to obtain the information generally by some non-invasion, by some means that didn't invade a privileged communication. And I think it's critical to the court's consideration of the analysis here that the subject matter of this statement and the entire circumstances surrounding this employee's involvement in the incident was all at issue and revealed approximately 15 months before this case went to trial. Ms. George, the employee in question, had been deposed on May 21st, 2018. And I'd also point out that the statement in question was on a privilege log produced by Walmart, and that's at the record at 115 and 116. So the plaintiff was aware over a year before trial that there was this statement for which Walmart was asserting privilege.
Counsel, if I may
yes.
just interrupt you quickly.
Of course, Your Honor.
Because one of the first things we have to do is look for preservation in any case, and I'm sure you probably expected questions about this. So as I read issue 2, and I'll just start with that one, you say the trial court erred by allowing plaintiff's attorney to publish the statement to the jury and admitting the statement into evidence. But then as I look at the trial transcript, and I realize counsel was not you, it was your client, your client's counsel at the time. But when the trial court said on page 4303 of the record, do you have any objections to Miss George's statement coming to evidence? Counsel for Walmart said, no, Your Honor, pursuant to our discussion. And I know, I recognize in the brief, you're doing the best that you can. You're trying to spin this reply as though no meant yes, because she said pursuant to the discussion. But if she wanted the no, the yes, no to mean yes, then why would she not just say, yes, Your Honor, pursuant to our discussion? By saying, no, Your Honor, shouldn't we as an appellate court say there was some strategic decision being made by counsel at this point to go, well, hey, at least, maybe our trial's not going as well as we want it to do. It's, evidence didn't come out like we wanted it to. So let's just give this statement a shot, which seems to imply that this lady's a total fraud because this witness statement that nobody can really validate says she was fraudulent. So it puts us in a tough spot as an appellate court. How do we see this from your side? Wasn't this effectively telling the trial court, it's okay, Judge, we made a strategic decision to allow this statement in?
Of course, I understand the court's question, and I respectfully suggest that preservation here is clear for a variety of reasons. I'd start from the premise of one should look respectfully at the totality of the circumstances surrounding the discussion involving the statement. And if we look at the totality, we start back, for example, at the record or transcript at 4295 and 4296. The colloquy is critical. Trial counsel says, Your Honor, nobody's disputing. Before today, we spoke with plaintiff's counsel. We don't know what we're going to get today. So I don't know her in 2016 or whatever, but I'm saying the concern is the statement Your Honor can see is a mixed bag of stuff, things that would be potentially helpful if she remembered them, not helpful. But I think that the key in the statement that establishes that she was working that day, the other portions of it turn into a mixed bag as far as what is that. And I have just a concern about how that is going to play out to the jury. And that is why we have maintained our work product. The judge says, I know what you're saying. I'm looking at the statement and I'm reading it. Obviously, plaintiff's counsel doesn't have the benefit of that. So it's hard for them to respond. But we're in a trial where she's displaying being there. And I do find they have shown need and inability to obtain the substantial equivalent. So I will pierce the work product privilege at this point. And then trial counsel says, well, maybe we can have Ms. Georges questioned outside the presence of the jury. And she says they don't need the entire statement. There was an entire back and forth by trial counsel, really just putting out there everything I think that at that moment, trial counsel could think of.
But counsel, at that point, there was no pending request for admission of that exhibit. That entire discussion you went through with the colloquy was strictly on whether the work product was going to be pierced. And so when there's no pending request to admit something to evidence, you're saying that later, if a lawyer says, when asked the specific question, any objection, now that it's being requested to be admitted, number one, when a trial court hears the word no, it's to assume that means yes. And then no coupled with pursuant to our discussion, that goes back to a discussion that has nothing to do with admissibility at all.
And it didn't ask for redactions.
Well, at some point, Your Honor, and I understand, of course, that at that moment in time, I mean, if the court is going to examine that specific moment.
It's an important moment, counsel. It's the moment of admissibility. Or don't act like it's some tiny moment in a scheme of things. It's the time of admissibility of the document.
But Your Honor, this is where I respectfully disagree. It's not just one moment in time. It's a moment that followed an entire colloquy of argument about the inadmissibility of the issue, about the.
Where's the discussion about admissibility?
And I'd start from the premise. Let me, if I may back up, I'd say two things. First of all, let's start from the premise of the trial counsel said, no, Your Honor, pursuant to our discussion. Now, if counsel should have said, yes, pursuant to our discussion, you know, the mixed words in the moment, there's no magic words, as the court is well aware. There's no magic word.
Yes and no are fairly magic. I mean, you're saying there's no magic word, counsel, but if the lawyer had said yes, we wouldn't be asking you these questions, would we?
I understand.
But yet, so would you concede yes really would have been a magic word, wouldn't it?
I think yes would have been a better word.
Okay.
I don't think it would have been a necessary.
Would yes have clearly made what made it absolutely clear to the trial court that there was an objection?
I think, Your Honor, that would have been clearer. But
Okay.
I don't think that the fact that the counsel in that moment said no pursuant to our discussion, I don't believe that the issue of preservation should ride on that moment in time when we have an entire colloquy of argument.
Counsel, let me ask you this.
Yes, Your Honor.
Can you cite to me one case where in response to a judge's question to a party as to whether there's an objection, they used the word no, and an appellate court said, in the context of everything that had happened, the trial court should have known that meant yes?
Well, in Mitchell versus State, the concept of accepting subject to, the words were subject to an earlier discussion or earlier objection. I can look specifically at the words, but we've cited this in our brief. It's at Mitchell versus State, 620 Southern 2nd, 1008. And the idea of accepting something, quote, subject to, unquote, a prior objection or prior discussion.
So counsel used the word exception instead of objection?
No, they
Okay.
said accepting subject to. In other words, we accept, for example, and I see this all the time. When during jury selection, for example, the court will ask, do you accept this panel? And the counsel will say, yeah, yes, we accept the panel subject to our prior objection or subject to our prior discussion. And I see cases like that fairly regularly. So the idea, again, of an affirmative statement here, the affirmative statement being, no, we have no objection. So it's a negative statement. No, pursuant to our discussion, I would submit that should be examined in the context of the colloquy. But I'd also start respectfully from the fact that we never should have been in that place, because this is about the privilege. So we're talking now about the admission of the document, but I don't think the court even needs to get there, because the first inquiry is whether or not the statement should have even been revealed. And if we go back to the question of privilege, and we go back to the fact, I go back to the point that a year and a half earlier, plaintiff's counsel was aware of the existence of this privilege statement. It's at the record at 115, 116. At during Ms. George's deposition, taken a year and a half earlier, counsel for the plaintiff was aware that she was disavowing.
Does any of the case law on need and inability to obtain have to do with when they brought the request? I mean, all the cases I read go through whether there's a need and whether there was the inability to obtain. This idea that there was some delay between when they, should have found out about their need and when they made the request. I don't see that in the test. I see need and inability to obtain delay in seeking to obtain, I don't see addressed anywhere in any work product doctrine cases.
Well, Your Honor, I think there's a general principle at work here.
You got to give me, if you're going to say there's a principle, you got to give me a case recognizing the principle.
Well, the
counsel.
general principle is that a person sits on their hands.
But you don't want to say, you don't get to tell us principles. You have to give us cases with principles. That's how this works, counsel.
I understand, Your Honor, but I will just state that when a plaintiff is aware of the existence of a privileged communication and does not move to compel production of that, then generally speaking, to wait a year and a half, notwithstanding being aware of the fact that it exists. And so let's go back to where we were.
Is there any case in the history of the state of Florida telling us that's something we should consider in the context of work, of deciding whether work product should be pierced?
The concept of waiver.
Yeah, delay. The fact that somebody delayed. Is there any case in the history of the state from any court, trial to Supreme Court, that says that's a relevant fact?
Well, I will, I'm not aware off the top of my head of a case that discusses.
I mean, you briefed the whole case. Did you find one?
Well, Your Honor, I think that there's.
If the answer is no, you can just say it, counsel.
Well, the answer to your question is I'm not aware of a case that specifically addresses that point. But I would respectfully submit that there is a pretty well-established notion that if a person does not move on a specific document that they're aware exists, waits a year and a half, and then in the middle of the trial reveals it for the first time that they're seeking it. I think there are, again, respectfully, general principles of waiver. And if I find a case, I'll provide a supplemental authority on that precise point. But moving forward again to the moment of trial, and let's assume for the argument, I'll accept the court's point that shouldn't even be considered. At the moment in time when they're at trial, plaintiff's counsel still had a burden of showing that there was a need for this statement.
Do they really have that burden?
Yes, they do.
Well,
100%, Your Honor.
But, you know,
they absolutely have that burden.
in the colloquy that you mentioned, and I did read the entire transcript on this very interesting witness, which of course, you know, you agree, we can't see a lot of things. We can't hear the tone of this witness. We can't hear the tone of the lawyers. We can't hear the tone of the judge. But clearly, would you agree that even the black and white transcript reveals there was a concern about this witness's veracity by everyone, seemed to me.
And there was a question of her confusion, veracity, undoubtedly. The question, though, was it necessary for the purposes of the plaintiff's burden?
Well, but then the trial judge, didn't she, in one instance, wasn't she sort of reflecting on, seemed like the witness may be nervous, first time in court, but then the judge said, but there's still, and then she gets cut off. Now I can almost finish her sentence. There's still something about this witness that's bothering me as a judge. And a judge has an ability, do you agree, to make sure that the jury gets truthful testimony? A judge can't be party to untruthful testimony being presented to the jury, can it?
Certainly not.
Okay.
But there was nothing about Ms. George's statement that was work product that had anything to do with the plaintiff's burden of proof.
But didn't she say to plaintiff's counsel that when plaintiff's counsel is talking to during, again, there was a lot of discussion. Didn't plaintiff's counsel ask her, well, would you be surprised or something like this, that there's a statement that you gave a statement? This is after, of course, her denying what everyone else in the room seemed to agree was her on the video, that he asked about the statement. And she said, I don't remember. I'd have to see my signature. Do you recall something, words to that effect?
Ms. George's was clearly confused about whether it was her veracity or her lack of recollection. There's no doubt about that.
And she needed an interpreter.
That's correct.
Okay. So under the rule, the witness has a right to request a statement given any time without the showing that need and all that, right?
No, Your Honor, that's inaccurate. Respectfully, the
1.280B4, doesn't that allow a witness without a showing to get a statement?
Oh, in order to have a recollection refreshed.
No, to request a copy of the statement under rule 1.280B4.
It's an exception to work product counsel. The person who gave the statement can always request it.
There's a difference. I understand. That's the person giving a statement. That has nothing to do, respectfully, with the plaintiff's ability to obtain access to our work product.
But couldn't the trial court view that as a request for her statement? And since she has a witness that maybe she's thinking about I might have to advise this witness of the consequences of perjury and perhaps give her notice of counsel or something, because I'm concerned as to what I'm seeing before me. So I'm going to give her the statement because she doesn't speak English. She apparently can't recall the statement, but she could request it with no showing. And so where's the substantive? There's really no substantive error by the judge. Is there? At best, it's a procedural error.
Again, Your Honor, I disagree because Ms. George wasn't the person to whom the statement was being shown. Plaintiff, our counsel asked for the statement to be given to her to be questioned outside the presence of the jury. The
Counsel,
judge-
you're into your rebuttal time, just.
The judge overruled that request.
But you would agree that if so, it's again, isn't that procedural though? Because couldn't the judge say, give the statement to the witness, and then once it's in the hands of the witness can give it to whoever she wants, and couldn't the judge order give it to counsel?
I disagree, Your Honor. It was our work product. The witness did not have the right to take her statement that was our work product and hand it over to the plaintiff's counsel.
Isn't there case law that says a witness can request a statement that was work product and he do with it whatever the witness wants?
Your Honor, the plaintiff did not have the right to unveil the work product. This was an-
Fact work product, not opinion work
That's
product.
correct. This was an accident report prepared by Walmart or within Walmart's control. And that, by the way, Your Honor, the way Your Honor outlined that kind of hypothetical is not what happened here. And that's to be clear, there was an opportunity to question Ms. George's outside the presence of the jury to see if it refreshed her recollection.
Counsel, let me ask you a different.
And by the way, it did not.
You're into your rebuttal, so if you want to hold your time, you
Let
can.
me
You're
ask you a
welcome to
question
that.
before you go by
Of
me.
course.
One of the things juries get to do is just decide who's lying, right? And that's in all the jury instructions. You get to look at the witness and you get to evaluate their truthfulness, look at their demeanor, and you can decide, we believe that this witness, we think this witness is a liar, right? And that's certainly something a lawyer can do, is say, yay, to the jury in closing or elsewhere. You observe the witnesses, you decide who's telling the truth. Okay, so by Walmart's own admission, this was the woman who made the mistake that Walmart is liable for, right? She cleaned the bathroom. You admitted she was in the video.
We admitted she
Right.
fell, we
So,
admitted
yeah,
the
yeah.
video.
So
we
here's my
admitted all.
point. If I'm the plaintiff's attorney, okay, and I have the witness who's liable, who committed the wrongful conduct, right? And even, whether or not she understands she might be liable, a person who was responsible for a, $1 million lawsuit may feel nervous, may not know the consequences, for whatever reason, may have had a motive to lie, right? And so if I'm the plaintiff's counsel, I want the jury to see her confronted with her lie and watch her look like a liar, right? I mean, even if you think the witness is going to continue to deny it, even if you know they're going to deny it, right? Even if the words that will come out of their mouth on a transcript wouldn't help you, right? The jury observing them being confronted with their lie can be very, very powerful. If the witness sees that statement and starts squirming and getting nervous. And so I guess what I'm saying is the need here, even if you assume that it was stipulated, she was the person who's liable, right? And even if you assume that there were mistakes made, when we talk about the issue of credibility, it's not just what she would have said and what she denied. It's this is the person who's liable and Walmart's liable for her conduct. And to see her be confronted with her lie kind of shows a level of intent on her part, right? Or a level of acknowledgement of wrongdoing. Is that not fair game?
Your Honor, in this instance, based on what the language was in the statement, there was absolutely nothing about that statement that had anything to do with exposing anything that Ms. George.
No, it shows she was in the video.
But I understand, and we admitted she was in the video.
I know
We
my point
stipulated-
is,
Your admission doesn't get the jury the visceral effect of watching her be confronted with her lie. And those types of things are fair game. She was the wrongdoer for which you are liable, right?
And again, Your Honor, there was simply zero correlation between the statement in that work product document and the proof that plaintiff had. I know I have about a minute left, so if I may reserve the rest of that.
You
time.
may, counsel.
Thank you.
Maybe give you a couple extra minutes. All right, counsel, you may proceed.
May it please the court. My name is Brian Lee. I represent Jessica Amador in this appeal. Statement is the statement. We going into trial, and I think you've seen it from my brief. The reason that this didn't become an issue until Miss George testified as she did, I think Mr. McAfee talks about it, and is that they were under the impression, albeit impression that didn't come to fruition, that Walmart was going to not contest anything about it. That she was the one who went in there, she cleaned it, all the things that it did. Mr. McAfee told the judge that when he sought the statement. And so this whole colloquy that went on, it was not so much about a need-based inquiry. It was about whether there was some kind of substantial equivalent. There was certainly.
Counsel, didn't they effectively agree to stipulate that she was the person on the video?
I don't believe they did. And
Why do you say that?
Here's the reason why. One of the first arguments in defense in Walmart's counsel's opening statement was that they were disclaiming that she was even in there, Mrs. George's was in there putting water on the floor at all. Because one of the things that I cited to in my brief was that they said it could have been anybody. It could have been the customers coming in and out that spilled something on the floor. So they were contesting one of the hardcore facts that the plaintiff would have to prove in that case.
Counsel, the statement didn't go to any of those facts. The only, when we got to the need argument, I got the transcript, your trial counsel said we needed to establish that she's the person in the video. Walmart didn't dispute that. Establish that Miss Georges was in the restroom. Walmart didn't dispute that. And establish that she was aware of the plaintiff's fault. Since she was in the video, that wasn't disputed. So like the things you're saying, they're all big points, but it wasn't the argument your trial counsel made below, and none of those things were established by the statement.
I would disagree, and here's why. The statement says, I'm looking at it, this is Mrs. George's, obviously. I cleaned the bathroom before I started. Before I started, I put a wet floor sign. And then after finishing, I was on my way out, and then the two ladies come in and it goes through. And so what Walmart said is, we're not contesting that she fell, meaning Miss Amador. We're not contesting that that's Miss George's in the video, but they were contesting everything else. They were contesting that Mrs. George's put the liquid that was on the floor in the bathroom that Miss Amador fell on.
The video doesn't show the inside of the bathroom.
And the statement,
And it does not.
And the statement doesn't resolve that issue.
Well, it does, Your Honor, because it says I cleaned the bathroom. Miss Georgia says I cleaned the bathroom, and so that you see them out, right? You see everything that's there. Miss Georgia said I cleaned the bathroom, and then the people came in, and so that establishes the need is established because the plaintiff has to establish how the liquid got on the floor. And Miss George's, as you saw, was disclaiming every single bit about it. That she wasn't there, she wasn't the one who did it, she doesn't know what happened.
Did Walmart
All of
dispute that she put water, or did they dispute that we knew that that was the cause of the fall, right? I remember them basically saying, Judge, there were other people in there. There could have been other sources of this water. I didn't remember hearing Walmart dispute that she put water on the floor. They disputed that that was the water that the woman fell on, right? That the plaintiff fell on. And they said, Judge, there was other people going in there. They could have washed their hands. They could have spilled water. I heard a dispute about the water that caused her fall, not whether Miss George's put water on the floor. Am I missing something? If I am, you can tell me.
Sure, and it says, this is from the defense counsel's opening statement. It's at 3963 of the trial. And she says, for the water that Mrs. Amador says was on the floor, who created it? Was it any of the 8 customers that walked in after her, using facilities, washing their hands, flushing, the kids going in and out? Are any of these customers responsible? Has she proven to you otherwise?
Well, yeah, that's my point. She's not disputing that Miss George's put water on the floor. She's saying who put the water on the floor that the plaintiff slipped on. There's nothing inconsistent with say, yes, Miss George's cleaned the bathroom and there was water involved. But we don't know that was we don't know that's the water she fell on. We don't know that's the water. We don't know if somebody else put additional water on. You see what I'm saying?
Well, I don't believe that there's, I mean, at least I didn't find it, and surely correct me if I'm wrong. I couldn't find anything in the record where Walmart said, yes, we put water on the floor. Or that Miss George's put water on the floor. I couldn't find that anywhere in the record, nowhere. And so when and especially as this court knows, we're talking about a transitory foreign substances case. The plaintiff has a high burden under that case, certainly under the newer statute, 2010. And they not only have to prove the negligence of it, why they were negligent, but they also have to prove the notice of it. And one of them is actual notice. If Miss Georges went in, cleaned the floor, and then there was slip, Miss Amador could say it's because she cleaned the floor. And we have the ability as the plaintiff to prove that. When we tried to prove that, Miss George, Walmart did not concede that she went before she cleaned the whole bathroom, and certainly didn't concede there was a wet floor sign, because there wasn't. So when they go in there and say that in their opening statement, that testimony, and oh, by the way, if we go later in the trial, the same defense counsel moved for a directed verdict on the issue of liability, on actual and constructive notice. That same attorney said there wasn't any evidence of notice that the plaintiff put on. And so it absolutely was a defense that Walmart was bringing throughout the entire action. That's why the statement's relevant. The trial court found that the need was established just based upon the fact that it would be for impeachment.
Now, counsel, what do you make of that? I take your point, and well said. One of the things they put in their answer brief that I didn't really see a response in your reply brief was that just basic developing of the evidence and resolving inconsistencies in stories is not enough to demonstrate a need to to pierce the work product doctrine, that it's some higher need. And I think you've done a capable job of explaining why this was relevant, but we got a lot of cases that say relevance isn't enough. Like just the fact that it disputes some other piece of evidence is not enough to establish need. And I didn't see any response to that in your reply brief in terms of disputing those cases.
Sure. And frankly, I think it's because I didn't need to, because this was not a inconsistency. This was not a situation where a witness says that I think that the person was going 50 miles an hour, and then later on the stand says they were going 45 miles an hour or 55 miles an hour. Something that's an inconsistency that other people will definitively talk about in the trial. So it's an evidentiary thing. This is a situation, the testimony that we're talking about, the statement that goes to that was critical in this case. And it wasn't an inconsistency. It wasn't that she said, well, yeah, I went in there, but I stood there and it dried and then I walked out. She said, I didn't even go in it. She disclaimed every bit about it.
Right? Isn't that an inconsistency? A blatant inconsistency, I'll grant you, but it's still an inconsistency.
I don't think, I think inconsistency to me is something that when you look at it, it doesn't mean a difference as far as what a jury would look at it. It's something that, yeah, it's inconsistent, but it's not something that they can hang their head on. In this case, it absolutely was. And at the end of the day,
I mean, is that because, I mean, you would concede your client has a bias that could be attacked by the defense saying, well, of course, she's going to say that it's Walmart's fault and she fell because she has a motive in this case.
yeah, and they certainly did that.
But you still bear the burden.
I do.
And so if you could prove the case through a defense witness, that's better, perhaps, for a particular jury.
Right. I mean, obviously, the best witness, if you can do it, it's the defense witness that proves your case, because you can show that they're certainly not biased for your client.
And that letter puts her in the bathroom.
It does.
Coupled with the video.
Yes.
So the jury will be instructed to consider all the evidence, right?
Right. And I don't want
And as
to
Judge Mize,
sorry, go ahead.
on questioning, if they get a feeling of mendacity when she denies that she did anything wrong, they could draw an inference that she did everything wrong.
Yes.
Sort of like she testified about the person who wasn't her doing everything wrong on the video.
Exactly. And it's, I don't think that there is something, I can't think of anything more relevant than the defendant's own employee saying that I'm not in that video. That's not me. I didn't do that. That is something that is to the heart of what her testimony was. And the jury was left.
In this particular
In this
case,
particular case,
because that is the person who cleaned the bathroom. At least
Yes.
that's what your client was alleging.
Yes, and I will note too that you mentioned that, you know, obviously, and look, defense counsel and defendants can attack the credibility of the plaintiff. It's part of the jury instructions. I mean, the jury's been, you know, instructed on that. But this wasn't the only part of attacking. Later on in the trial, I mean, obviously there was attacking during her testimony, Miss Amador's testimony, but even through their own CME, Dr. Rust testified about when Miss Amador was in the examination with him, and she was telling him pain complaints, and he didn't find that consistent with it. And he just flat out said, yeah, I don't know why she was telling me those pain complaints, because that's not consistent with what I'm seeing in the records. And so this wasn't like this was sort of a kind of a one-off thing where, well, this is the only reason why, you know, we're not assessing the credibility. We're not attacking this plaintiff, and this should stay out. In various parts of this trial, they built on attacking the credibility of Miss Amador. And I think the trial court, in kind of a more of a fortune teller, said at the beginning, when they were talking about need, says, look, you know, I think the need is shown by just because it can impeach her, which it did. And so once it's actually in being able to be used, it's used by counsel. There's no question that there's no objection to any of the questions that he's asking Mrs. George is about the statement. There's no question that she's still denying everything about the statement.
Well, there was a foundation objection.
It was. And then at the end, as the court's already talked about, when asked specifically whether it's going to, our defense counsel had any objection to it being entered into evidence, which obviously is very different than just using it as a witness. Defense counsel said no. And so everything that happened after that point, which I know that they've argued in their brief, that Miss Amador was asked about it during her questioning, that plaintiff's counsel then used it in his closing arguments. Every bit of that is something that he absolutely was entitled to. It was part of the evidence of the case at that point. Counsel, of course, can testify. Talk about that.
If we were to read their response to the trial court's inquiry, you know, any objection to the admission, they said no pursuant to our discussions. If we were to adopt their interpretation of that and say that in context, it was a reiteration of their objection, does your argument about the propriety of those questions in terms of fraud allegations made in the statement, and the fact that was brought up in closing, if we assume those were objected to, does that become a lot harder for you?
I would say no, Judge, because of the fact that it wasn't just that particular scenario that Walmart was saying that she was making things up.
Well, yeah, but I mean, you obviously, if they're asserting that your client is uncredible, you have a right to dispute that. But what brought in the statement wasn't disputing her credibility. It was bringing another allegation against her credibility that they did not make. Right? Now, I understand your argument on waiver. If we disagree with you on that, though, and decide it wasn't waiver, I'm struggling to see how those allegations were relevant.
Well, Walmart is, to me, Walmart is saying in their briefing in this case that we aren't making any allegations that she's committing a fraud.
Well, I mean, just by disputing your lawsuit, they're saying that, you know, that what she's saying is not true. But whatever allegations they made, arguments they made against your client's credibility, they didn't make this one, right? And the allegation in the statement, you know, that she said, oh, we're cashing in against Walmart. You know, they didn't say that at trial until except us through this statement, right? And that statement, that portion of it, that didn't rebut their allegations about your client's credibility. It added to it.
I would agree that it added to it, but I also think that,
and it was inflammatory, was it not?
Actually, I think it was true of what Walmart was doing. I mean, whether something's prejudicial or inflammatory certainly is in the eye, in this case, of the trial court.
But I'm saying you don't get to prejudice if it's not relevant, right? It was, yes, obviously, things that make you liable can be prejudicial, right? So it has to be improper and prejudicial. But here's my point. It didn't go to duty, causation, breach, or damages, right? It's a negligence case. It didn't go to the elements. It didn't go to the attacks on your client's credibility. It seemed to me that all it went to was making Walmart look like a big bad corporation that's trying to bully this woman.
I would disagree.
They put words in Walmart's mouth that they did not try to put in their own mouth at the trial.
I would disagree that it doesn't go to Walmart's attack of her credibility. Just for the very fact that Miss Georges is an employee of Walmart, and so what she says matters.
Well, that's my point, right? So it added an attack on her credibility. So yes, it went to the attack on her credibility, but not in the way you're entitled to do, right? If they attack her credibility, you're entitled to dispute that. What this did was put another attack on her credibility, right? As a way of making Walmart look like a bad guy.
I mean, I understand what you're saying. I mean, if the statement would have came in without redactions, I would agree to you, or with redactions, excuse me. And if they had redacted that whole part out.
That's what I'm saying, right? So it came in because, under two different interpretations, right? Either they said no objection, or as Walmart's counsel would like us to find that was actually a reiteration of their objections.
Right.
If we assume that they were objecting, right, and that it came in without redactions over their objection, right? It seems to me argument gets a lot harder as to that not being improper. Even if you assume you were entitled to get the statement in terms of invading, admitting those fraud allegations, that seems to be completely irrelevant and pretty inflammatory.
Well, I think when you get to that point, though, the trial court's making that determination.
Yeah,
Counsel,
we're reviewing it.
And the trial court reviewed it.
Yeah, counsel, if I could build on that just a little bit. So, as I read through the unfolding of how the document was first exchanged and then later admitted and somewhere in the middle discussed on the stand, the starting point was the court saying on 4294, that the court said that your client had a chance to look at it. The court said, I think the plaintiff has shown they need it in order to impeach or whatever they want to do, at least to see it at this point. Okay, so the court is saying a need to see. Then we get to, okay, well, how's this all going to unfold? Definitely, I think a very clear discussion that the document was signed by Ms. Georges, or at least everybody thinks it was. But then within the contents of the document, counsel for Walmart saying, well, there's a mixed bag of stuff within the document. But then we get to the portion of the record where that I want to question you about, which is when the court says, now to brass tacks, we're actually going to question her about it. And you wanted her to be questioned on the stand rather than privately. I don't know if that's a big deal, but the court said, Mr. McAfee, what do you intend to do with the statement? Walmart's counsel steps in and says, show it to her first, ask her to identify it, ask her to read it. The court starts to say something and then gets cut off by plaintiff's counsel, who then says, then I've got some follow-up questions on that was you on the video. And that's what your counsel did. They showed her the statement. They said, read this statement, look at this statement. Is this your signature? But rather than saying, is that you on the video now? Then they get into the contents of the statement.
Right.
I don't understand why. I mean, even your attorney said, given her lack, the court said, given her lack of following instructions, her inability to provide responsive answers, you need, Mr. McAfee, you need your questions to be really tight in order for her not to cause any issues. And I think everybody here understands what the court was saying, not to cause any issues with that, with what potentially was a privileged document, right? And your counsel says, I'll cut her off. Mm-hmm. But instead of cutting her off, he then gets to where he just, rather than just ask the question, go through the process. Here's your witness statement. There's your signature. Okay, let's try this again. Was that you on the video? He then goes into this whole colloquy of asking very specifics about the statement that, frankly, I don't think add anything, didn't accomplish anything, except cause everybody to be here today. So what do you what's your response to that? You know, doesn't it appear that at least at the trial level, your own attorney was saying, I'm going to cut her off, but then he didn't? Why shouldn't we say that that's some concession that you all were making, that this was inappropriate work product and shouldn't have been going into it at that point in time?
I don't think that saying, well, I'm going to cut her off, that could be frankly for a lot of different reasons.
And I apologize. I've run over your time.
Oh,
I'm going to give you, I'm going to
okay?
give you a
Is it all
couple
right?
extra minutes because I'm going to give your opposing counsel a couple extra minutes because we asked a lot of
Sure. And you know, the questions that were asked afterwards, were they dealing with, was she cleaning the bathroom? No, they weren't. It's clear that that's the case, but it's not. I don't believe this court can then come in because there was zero objection by the defense to any of those questions. We believe there's zero objection then to them saying the statement can come into evidence. All right. Now, I don't know why that was the case. If you believe the defense argument is that we didn't want any of that to come in no way, no how. And then when the question's asked, they're silent. I don't know why that is.
I don't disagree with you on that point, counsel. I wanted to hear what your response was.
Right.
I would have expected defense counsel to object.
Yeah.
And they didn't. Is there anything else you wanted to close with?
No, Your Honor, we've just asked that the court affirm the trial court order.
Okay, thank you.
Thank you.
And counsel, I'm going to give you a couple extra minutes, so I can go as well.
Thank you, Your Honor. So I'm going to go right to the last point you went through with counsel for plaintiff. Once that statement was allowed to be presented in its entirety, the damage was done.
When? Because I mean, to me, that is a critical issue. I asked him, and I'm gonna ask you the same question.
Absolutely.
Question. So all I see from the trial court's perspective is they can see the statement. I don't see any harm. I don't think anybody's saying that that's where the harm occurred. The harm occurred when the testimony started, when the questions were being asked about the specifics. I don't even know that anybody would say that necessarily you would have had an appellate ground if you would have just seen the statement and said, is this your signature? But that'd be a hard argument to say that, you know, now we've so blown apart work product privilege, maybe, but I don't think that was your argument. Your argument was on appeal, the statements.
Well, can I tell him that they get to see it part? Like, I think what Judge Smith is indicating, or at least what's making me latch on to is that indicates it was just a ruling on the work product division,
Yes.
which I get your point about that being wrong. But that they at least get to see it part, whatever flaws there were with that ruling, right? And I think you make a really persuasive case that there were flaws with that ruling, right? But that they just get to see it part of the ruling makes us think it was cabined to the issue of invasion of the work product and not the substantive questions about it and the admission of the document, for which there's a really strong waiver argument.
And so the response to that, Your Honor, is that if I have to look again at the colloquy, because there was so much, we start and Judge Smith was reading from that portion. It's 4294 of the transcript. It continues because Ms. Morales, the trial counsel, she talks about, well, she should be questioned outside the presence of the jury. Then she says it's a mixed bag. At one point in the colloquy, she suggests that only the first part of that statement, if anything, is what's at issue here. And Judge Mize, as you correctly point out, the use of the statement went so far afield, but it was because, but the problem was that the Judge Beamer, when she ruled, she said, I'm gonna let them question her about it. She didn't cabin, as Your Honor used the term.
She didn't rule any specific questions, did she, counsel? Like, a trial judge is entitled to make a limited ruling, aren't they? And she seems to say, at least to see it at this point. Right?
Well,
like that, I think all three of us, it's making us latch on to the idea. I'm telling you so you can dispel it, right?
Understood.
It seems to make us feel like that was a limited ruling, which a trial judge is entitled to do, right? And one thing that I think there's an argument that it does, at least, is that did put a burden on your client to say, okay, what are I need to make specific objections.
And the problem, Your Honor, I totally understand the court's concern, but under 90.104, once the trial judge had made her definitive ruling about the admission of the statement, the right of counsel.
Where's the definitive ruling?
The definitive ruling is, if we go to page 4296, it's 97 of the transcript. And she goes on, and again, it goes on, and I pull it from the colloquy, but the definitive ruling is, she says, I will pierce the work product, that's at 4296. Ms. Morales, I would just ask if it's going to be used, that we first question her outside the presence of the jury. It continues, the court, page 4298. I'm going to deny defense's request to voir dire her or proffer testimony prior to trial. Given her lack of following instructions, and her inability to provide responsive answers, Mr. McAfee, you need your questions to be really tight. But then it continues.
So no, you agree up to that point, there's no definitive ruling on an evidentiary objection. Not a discovery objection, not an alleged wrongful to voir dire the witness. None of that is evidentiary.
I agree with that. But my belief is that once the trial judge allowed the statement to be presented to the jury, it was sort of in for a penny, in for a pound. It was the damage was done. The entire statement was revealed. Once the entire statement was revealed, I consider that to be a definitive ruling.
But it was
Judge
revealed,
allowed-
revealed through questions that came after that ruling.
No, Your Honor, no, the judge, I believe plaintiff's counsel actually read the entirety of the statement
After the judge made that ruling.
after the judge allowed counsel to do it. So the question is,
Well, the court allowed it because didn't hear the word objection. That's what trial
Well,
judges do.
Your Honor,
Is we allow questions unless we heard that magic word objection.
but Your Honor, the objection all came in the context of not allowing the statement itself to be presented. Trial counsel so vigorously argued against the admission of the statement. I think the problem is there is a futility argument too. You know, once the objections had been made and the argument had been made, and there was a request to allow only a portion of the statement, because as Judge Miles, as you noted, there was absolutely nothing that the rest of it had anything to do with anything in this case, other than to make Walmart look bad. And that's why they wanted it once they saw it, and that's what they did with it. And I think, unfortunately, once counsel had three times argued against its admission, once it was revealed, the damage was done.
Counsel, let me ask you this, if you were there, you know, sometimes appellate lawyers sit in on trials and they give appellate advice.
Yes, Your Honor.
When that, when the judge said any objection to the admission, would you have whispered in that trial counsel's ear, asked for redaction?
Well, you know, Your Honor, it's a fair question, but here's my honest answer. Okay, in hindsight, there's always things that one would do differently. And I do go to trial very frequently, and I understand the court's point. But it's also in the moment of time, and that's why I said this before. We look at moments in time, but we also look at context. We look at preserved and unpreserved error together. We look at the totality of circumstances. And I would ask that when the court examines whether or not the issue is preserved here, we look at the entirety of the statements, because there is a futility point. Trial counsel is not required to repeatedly object over and over and over again when the court has already made it clear what the ruling is going to be. I know I'm way beyond my time.
We're
So
3 minutes over. So
Yeah, it's not exactly your fault, but counsel,
Let me ask you,
understood.
in your brief, you concede almost, I don't know, maybe I shouldn't use the word concede. That'll be my word. I won't say that's yours.
Fair enough.
But that, you know, like, well, at best, a certain portion was relevant. And so I think Judge Mize's point is there was no objection to or request for redaction. So if the entire document is not completely irrelevant, if the entire document doesn't fail a 403 analysis, then isn't it your client's burden at trial to point that out and request that to the trial judge?
Yes, it is, but counsel didn't use the word redaction, but she did. She
She
did.
used mixed bag, but how does that identify for the trial court? What's the mixed bag? What's supposed to be redacted?
Sure.
And particularly, again, you say the totality. It seemed to me, reading the transcript, that your lawyer thought that this witness was going to completely deny the statement. She goes, I expect the witness is going to deny this statement. But in fact, maybe to the surprise of everyone, once again, with this very challenging witness, she admits that's her signature, but then says that's not my statement. So all that context before, everything's sort of been turned upside down again, hasn't it?
So I don't agree with that, Your Honor, because our trial counsel did say that only the first part was relevant. She didn't use the word redaction, but she said the first part's relevant. She said that the witness should be questioned outside the presence of the jury to avoid the harm that ultimately occurred. She also, and by the way, it's also significant that she mentioned at one point, trial counsel, that the key to the statement was that it shows that Ms. Georges was working that day, something we stipulated to, something other witnesses testified to.
You got me again on
Gotta
that.
wrap it up here.
You got me again on that, counsel. I've been a trial lawyer,
Yes, Your Honor.
right? You're entitled to watch the witness squirm. Like, even if they knew she was going to deny it. If I was a trial lawyer, I said, Judge, we want the jury to see her deny it. We think they're going to look at her, deny it, and determine she's a liar. Right?
Understand.
And she's
Of
the one who
course.
did the wrongdoing, and that would be very powerful, right? I'd make that argument all day.
But I agree, but it had nothing to do with the rest of the statement. It had nothing to do with the rest of that statement, which is what everybody at the trial level, just like we today are talking about. It wasn't about, I was the one who mopped the floor that day. It was all of this stuff about they contrived and planned this. We all knew, the lower court judge knew what was that issue. And so I know I'm well.
All right, yeah, I'm gonna go ahead and.
I would ask that
folks.
this court reverse and remand for a new trial. I'll end with the other side. Plaintiff has never confronted or even mentions the special versus West focus standard. It is their burden to demonstrate that there was no reasonable possibility that this affected the outcome, and we believe it clearly did. We would ask that the court reverse it. Your Honor.
I
Thank
think
you,
the
counsel.
argument was so long because the case was exceptionally well briefed on. both
It was,
sides.
and it was well argued on both sides. So.
Very well
thank
done,
you, Thank you. all.
Gentlemen, thank you.
Thank you for that, Your Honor. We appreciate it. Have a good day.